Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
We will hear argument first this morning in case 19-465, Chiafalo and others versus the state of Washington. Mr. Lessig.
Mr. Chief Justice, may it please this Court. The question in these cases is straightforward. Do the states have the power to control through law how an elector may vote? They do not. The ordinary expected meaning of the words of the Constitution against the background of the framers' deliberation make it clear that the states have no such power. But what is also clear is that Washington does not like the Constitution's design. It asks this court to read the word elector as agent, or maybe better, minion, and it declares that the votes electors cast are not, as the Constitution expressly describes them, their votes, meaning the electors' votes, but instead of the votes of the state. Article 2 in Washington's hands effectively gives the states the power to cast votes for president in such manner as the legislature thereof may direct. But the actual Article 2 does not give the states the power to cast votes. It gives the states the power to appoint electors. And the actual electors that the Constitution creates have a legal discretion, as every elector does, not an unfettered discretion, as Washington puts it. To the contrary, a completely fettered discretion, just fettered by moral and political obligations, not by legal constraint. Washington's alternative to, quote, vest discretion in citizens rather than electors may be a better plan, at least if part of a coherent change, but the question for this court is not which plan would be better. The question is which plan is the Constitution's now. And the answer to that question is clear in the Constitution's text. The states get to appoint, no doubt, but they appoint electors who are then privileged to cast their votes without regulation by the state.
Mr. Lessig, do you object to the pledge itself? Assume there's no fine or any other sanction, is simply requiring a prospective elector to take a pledge okay in your view?
Absolutely, Your Honor. A pledge understood the way Ray understood a pledge, having no legal obligation but a moral obligation, is perfectly fine as part of the appointment power of the state.
Well then, so the addition of a sanction makes no difference?
No, the sanction makes all the difference. So long as there is not a legal sanction, then a pledge is appropriate. It's the same in the context, Your Honor, of the speech and debate clause. Of course, you can't punish somebody for a vote in Congress, but there's nothing inconsistent with a speech and debate clause in asking a member to make a pledge. Indeed, states right now ask members to make a pledge as a condition of being a party member.
So if there were a fine of $1, you would say that violates the Constitution, but if it's simply a pledge, no violation at all?
That's right, because a fine is a legal obligation. It crosses the line because the state has no such power to impose such an obligation through law.
So your argument is not that the sanction must have coercive effect. It's simply if it's only a symbolic requirement, it still violates the law?
No, Your Honor. It's symbolic requirement. It's, of course, an important moral requirement. It's a moral obligation when you take a pledge. But it can't cross the line and become a legally coercive obligation, consistent with the freedom that the Constitution grants electors to vote by ballot.
So by legally coercive, you mean something different than simply coercive. In other words, if you add $1, that becomes legally coercive?
That's right. Just as with the speech and debate clause, if you fine a congressperson $1 for his speech or his vote on the floor of Congress, that violates the speech and debate clause. But there's no problem with saying to that congressperson, to be a member of the Republican Party, you must pledge to support the platform of the Republican Party.
Under your view, there would be no way to enforce the popular vote referendum?
The National Popular Vote Compact, is that what you mean, Your Honor?
Right. I mean, assuming that gathers enough support and becomes law, there'd be no way to enforce it?
Well, Your Honor, that obligation requires the states to pick a select slate of electors that fits with the winner of the national popular vote, and that slate of electors then would have the same discretion, legal discretion that we believe any elector has. But of course, if there's a national popular vote compact, the number of electors for the winner would be so significant, it would be very hard to imagine any discretion affecting the ultimate result.
Thank you, counsel. Justice Thomas?
Thank you, Chief Justice. Mr. Lessig, just a preliminary question. Should we ask ourselves whether or not the state is granted the authority to regulate the vote of the elector, or should we ask ourselves whether the Constitution prohibits the state?
Your Honor, I think you should ask the question both ways, and it's the same answer both ways. The only argument the state has made in Washington, in the Washington case, is an argument grounded in the Appointment Clause. They don't invoke the 10th Amendment. So that would, the question is whether the Appointment Clause gives them power to control, and we believe they do not. But then you can look at it from the other side and ask, as an elector who is given an obligation to vote by ballot, does that obligation entail a protection from legal regulation? And we believe, just as the Speech and Debate Clause does, it creates an immunity from being punished for how one votes.
When you make your, I'm curious, when you make your federal function argument, does that depend in part on the fact, your view that the elector has discretion?
The federal function establishes the discretion, Your Honor. It's exactly the same as in the cases of Hawk and Lesser, where the question was a state legislator's discretion to vote on an Article 5 amendment. And of course, the state legislator works for the state. It works for the people of the state. It's subject to the Constitution of the state. But what Hawk and Lesser established is that that state legislator is free of the impositions of the state, either through referendum or on the Constitution itself, when that legislator votes on an Article 5 amendment. And that's the same immunity that we think a presidential elector has.
How do we determine what the contours of this federal function, would be?
I would look just at the text. The federal function in balloting, as Ray described it, is the function in casting a ballot as the 12th Amendment describes, and then the additional steps the 12th Amendment requires, which is to name the president and vice president, make lists, and so forth, sign and certify and send it forward. That's the function which the Constitution gives to electors, distinct from the power to appoint, which Ray also describes.
But does the 12th Amendment mention discretion?
No. The 12th Amendment mentions the vote, and of course, by requiring that someone make a list of the people that was voted for, it implies that there's more than one person that could be voted for. But of course, the 12th Amendment also doesn't mention the state at all. Yet the way the state conceives of it, the state is a proctor that stands in the room as the electors cast their votes, looking over their shoulder. But that's nowhere in the 12th Amendment, Your Honor. The state doesn't appear in the 12th Amendment except to name where the electors will meet.
You know, can the state remove someone, for example? I just wonder what limits, what authority the state actually has here. Can the state remove someone who openly solicits payments for his or her vote?
You could certainly, of course, this court has said in Burroughs and in Fitzgerald v. Green, the state can certainly regulate corruption, and bribery would be corruption. And we believe that it's absolutely clear that the state has that government has that power right now.
So where's the authority? Where does that come from?
Well, it's interesting. Burroughs itself, Burroughs versus the United States, of course, found it inherent in the federal power to be able to protect federal elections from corruption. In Fitzgerald versus Green, they saw it as incidental to the power to appoint electors to be able to assure that the election, in that case the vote by the people, was consistent with law. Either of those could create the authority to avoid corruption, but of course corruption, like bribery, is independent of the vote. You don't need to police a vote to be able to police corruption, just as with the speech and debate clause, you can convict a congressperson of bribery, even though the bribery includes the vote that might have occurred.
Justice Ginsburg?
Mr. Lessig, I was surprised at the answer you gave to the Chief about Ray. I would have thought that under your absolute elected discretion view, Ray should have come out differently under your theory.
No, Your Honor. We think Justice Jackson in Ray was completely right about the original understanding, and we think Justice Jackson was completely wrong about what followed from that original understanding. The framers did believe that electors would exercise independent judgment. That's absolutely clear. But they did not inscribe that belief into the text of the Constitution. They could have. Maryland's Electoral College had that text in the Constitution to constrain the discretion in a particular way. But our Constitution didn't, which means that the question in Ray was whether the state had the power to discriminate on the basis of political affiliation and loyalty when picking electors. And after the 12th Amendment, we believe that's perfectly obvious. They have that power to discriminate because that's the function that the Electoral College has come to occupy.
It's somewhat hard to understand the concept of something I am pledged bound to do. I have made a promise to do something, but that promise is unenforceable.
I understand, Your Honor, and it's difficult until we recognize how familiar it is. Every single political pledge is of this character. We couldn't find a single case in the history of political pledges where a pledge has been considered as anything beyond a moral obligation. We cited the Kucinich versus Texas Democratic Party case, where Texas requires candidates to pledge to support the candidate in the Democratic Party. And that was upheld explicitly on the ground that that was simply a moral obligation. And we can see that in the context of Congress again. Again, there's no problem with requiring a member of the Republican Party to pledge to support the Republican Party as a condition of being a candidate for Congress. But we understand the speech and debate clause to say you can't punish them for their vote. And the pledge is not inconsistent with the speech and debate clause. It's perfectly consistent because a pledge is always and only a moral obligation.
Thank you.
Justice Breyer?
Thank you. Good morning. Counsel, a state can appoint people, requirement that they be permanent residents of the state. That's all right, isn't it?
Of course.
Of course. And then could they say, and you must be a permanent resident at the time that you cast your vote?
Yes.
Yes. And then what happens if, in fact, Mr. Smith, who is a permanent resident when elected, changes his residency and goes to a different state before the vote is cast? You know, he is not a permanent resident. He hasn't met the state's requirement. And so could the state also say, in case that happens, we have an alternate who will cast the vote?
Yes, we believe they can, because the requirement...
difference between that and this situation where they say you must promise to vote for the person who wins the most votes, and then he gets to the room, and in that room he doesn't live up to that requirement, just as he didn't live up to the requirement that he be a resident of the state.
Your Honor, the difference is the line between the appointment and the voting. The Constitution draws that line. It says that Congress can set the time of the appointment, and they can set the day on which the vote is cast. And we believe incidental to the appointment power is the power of the state to assure that there is an elector there who will perform the function, the federal function of balloting. But once the voting starts, the state disappears. The state does not appear at all, except to name the location of the vote in the 12th Amendment. It certainly doesn't stand there to observe whether someone voted properly.
If, in fact, he changes his residence 10 minutes before he casts his vote, then you could remove him. But he can't. They can't, the state, when in fact he actually casts the vote. But surely a person who casts the vote for Jones instead of Black has in fact changed his mind 10 minutes before. And so can you not in fact remove him because of that preceding change of mind 10 minutes before?
No, because the pledge is a pledge made prior to the...
So it's not a pledge in my hypothetical. It is a requirement that he, in fact, not cast his vote, but that he, in fact, be a person willing to cast his vote for Mr. Jones, a majority winner, at least 10 minutes before. I'm just trying to make it as close as possible to the person who changes his residence 10 minutes before.
But again, Your Honor, the Constitution gives the states no power to regulate the vote. They have the power to appoint. And incident to the power to appoint, Ray said they can say, we must make a pledge to support the party nominee. And at the time my clients made their pledge, they absolutely intended to vote for the party nominee. So the regulation that's authorized by Ray has nothing to do with what you've described, which is the regulation of the vote.
Justice Alito? Justice Alito?
Yes, Mr. Lessig, my question is similar to Justice Breyer's, or at least it follows along the same line. Suppose an elector is bribed between the time of popular vote and the time when the electors vote. Can the state remove that elector?
Your Honor, we believe that prior to the vote, the state's power the incidental power exists to assure that the person who shows up has not engaged in engaged in a criminal activity. It's difficult to imagine how that plays out, though, because of course the claim someone has been bribed is a charge. It needs to be proven. And so we believe there's going to be a difficulty there with the bribery. But let's remember that the framers expressly considered this problem. George Mason expressly said the reason not to have electors is that they could be bribed. But what the framers saw is that there were two risks. There was the risks of elector bribery, but there was also the risk of cabal and corruption, as Madison put it.
Well, your argument was that your argument must be either that the electors cannot be removed by the state. The state says that at least some removal power goes along with the appointment power. So I think your argument has to be they can't be removed, or there are at least some circumstances in which they can be removed. And if there are some circumstances in which they can be removed, such as when the elector has been bribed, why would the violation of a pledge not be one of those circumstances?
Robert, we have said the bribe is different from a pledge because, of course, the bribe is proven separately from how one votes. So we've recognized that there's a capacity to regulate bribery. But what I need your question is perfectly framed because I do want to assert that there's no power to remove prior to the vote. The power that comes from, for example, 3 U.S.C. 4, which Congress gives the states the power to fill vacancies, is the power to fill a vacancy once the vacancy occurs. It's not the power to create a vacancy. And that's the structure that the Constitution establishes as well.
So the state cannot create a vacancy by removing an elector who has been bribed?
Yes, unless the bribery statute makes as a penalty a removal from office and there's a conviction prior to the actual time at which the vote has been taken. But that's a person.
One other question, if I can. Those who disagree with your argument say that it would lead to chaos, that where the election, where the popular vote is close, and changing just a few votes would alter the outcome or throw it into the House of Representatives there would be the rational response of the losing political party or elements within the losing political party would be to launch a massive campaign to try to influence electors. And there would be a long period of uncertainty about who the next president was going to be. Do you deny that that is a good possibility if your argument prevails?
We deny it's a good possibility. We don't deny it's a possibility, and we believe there are risks on either side, which is a good reason to avoid the risk-adjusted constitutional interpretation. We agree that, of course, the possibility exists that you could flip electors. But look historically at the number of times that could have mattered. In fact, in the history of electors, there has been one elector out of the 23,507 votes cast who has switched parties against the majority party in a way that it could have mattered. That was the very first time this happened, Samuel Miles in 1796. In the ordinary close election...
Justice Sotomayor?
Counsel, you compare in your brief the Electoral College to a jury, arguing that they are structurally similar under the Constitution. You can't remove a juror because of his or her vote. But if that's true, I don't see how that helps you. A juror makes all sorts of pledges to be impartial, not to discuss the case with anyone during the trial, not to research the case with the parties, to tell the truth during voir dire. Yet if a juror is selected and violates one of those pledges, say the juror talks about the case with the other jury members, the judge is empowered, with others than the jury members, the judge is empowered to remove that juror. So why isn't a presidential elector subject to being removed in the same way? He has made a particular pledge, different than remaining impartial, but he has told the people who have appointed him, I will vote in this particular way. You call it morally, commit myself. So why isn't that any different than a juror who says, I'm not going to do this, and then does it, and a judge can remove him?
Well, Your Honor, you've identified the core immunity that a juror has, and that is the immunity in the vote to convict or not. And we agree that is an immunity that cannot be regulated, can't be punished, it can't be fined for a vote improper according to the court or the state. But there are other obligations, you're right, that you can be held to account for. We think that's perfectly parallel with the presidential elector. The presidential elector has an immunity in his or her vote. But of course, sitting in the electoral room, he can't cause a disturbance, he can't threaten somebody with a weapon, he can't engage in any number of criminal activities that might, of course, interfere with the opportunity to perform the duty. There's no general immunity, there's a particular immunity, because the immunity to vote is an immunity from penalty for vote, just as the speech and debate clause cases have made clear.
Now, you rely a lot on history in your argument, but doesn't McPherson undermine your position very directly, just like Ray does in some extent? In those cases, the court made clear that whatever the framers expected, and here you make a good argument that some of the framers originally expected electors to have discretion, that historical practice since the founding offered a practical interpretation of the Constitution. That's what Ray said. And McPherson said, experience soon demonstrated that the electors were chosen simply to register the will of the appointing state. Don't that same principle undermine whatever you think some of the framers expected, that historical practice, at least since the 12th Amendment, has shown that states have imposed not just pledges, but have imposed fines and some removal of electors who are faithless?
Your Honor, first, no state has ever, prior to 2016, imposed a fine to remove the elector. But number two, Our argument has nothing to do with expectations. It is the state's argument that hangs on expectations. What we say is that the Constitution, as McPherson says, should be read not according to modern-day expectations, but according to the words, the ordinary expected meaning of the words the framers used in the Constitution. So in McPherson...
Mr. Lessig, so let me ask you about those words. As I understand it, most of your argument depends on a particular reading of the terms vote and ballot and elector. And of course, usually we think of those terms as involving some choice, but not necessarily. People are electors, at least formally. People vote, at least formally. People cast ballots, at least formally. At times when there is no choice. Think of a Soviet-style system. Or, think of somebody who has pledged himself to vote because another person is voting another way. So why do these terms necessarily involve choice in the way you suggest?
Well, Your Honor, we believe, as Chief Justice Roberts has described, that the best way to understand these words, the best dictionary, is the Constitution itself. The Constitution speaks of elector in two contexts. Article 1 speaks of what Justice Thomas has referred to as congressional electors, namely voters. And we believe the freedom of congressional electors is exactly the freedom of presidential electors. And we understand the authority of this court to establish that the office, as Justice Kennedy put it in his opinion in Thornton, the office of the elector there meaning the congressional elector, is created by the Constitution, and it's free of constraints, either private constraints or state constraints. So it's the same sense of elector that the Constitution used. Now, of course, they could have said, we mean by elector in Article 1, someone who has freedom and discretion, but by Article 2, we mean what will become the Soviet Union conception of elector. That would have been possible. We're not saying it's impossible to imagine this. We're saying the ordinary expected meaning of these words would have supported the discretion that absolutely the framers expected electors would have, and that at least retain.
If that's right, Mr. Lessig, if your reading is very deeply contextual, then shouldn't we look to what happened in the very first elections under the Constitution, where, immediately, right away, electors associated themselves with political parties, pledged their votes ahead of time, and it's that practice that has continued for over 200 years. So if your reading isn't demanded by dictionaries, but is instead demanded by context and history, doesn't the context and history suggest the opposite?
Your Honor, we believe the context and history supports the idea, absolutely, that electors were to pledge themselves. We're not saying that the Constitution required them to be Hamilton's philosophers. That's not our claim. Our claim is that the discretion that they created in the office of elector survives. So yes, look at 1796, where the first so-called faithless elector, Sam Miles, switches sides. This, of course, is noticed and objected to. And indeed, in 1800, that election also was complicated by the failure of electors to do what they were expected to do. Gallatin noted that to Jefferson and said to Jefferson, we should eliminate electors. And Jefferson said, yes, let's have an amendment.
Justice Gorsuch? Counsel, could a state, for example, ask an elector to make a sworn statement as to his present intention to vote for a particular candidate, make the pledge, an oath?
Yes.
And could a state later prosecute that elector for perjury if that statement under oath, if there's evidence that that was a false statement?
In principle, absolutely, Your Honor. We think in practice, that would be just like with a judge making a promise to a Senate committee upon prior to a confirmation. It would be incredibly difficult to imagine enforcing in a way that wouldn't be just retaliatory against a particular elector.
And could a state say that we'll pay your expenses and give you a per diem for your service, but only if you carry out your promise to vote in a particular way that you pledged initially?
No, that's what Washington's new law, in fact, does. That is, in effect, a penalty as well.
Why couldn't it do that if it could do the other things?
Well, again, Your Honor, the difference is between a legal consequence or a legal penalty based on your judgment, your vote, a federal function of balloting, which is free of state control, and the other incidental powers relative to appointment. And so in appointment, I want to make sure you're an honest person.
I'm interrupting, but I'm not sure I understand where you're going, so I just want to cut to it if we can. So a state, in my last hypothetical, is just simply saying we'll pay your lunch, your travel, and your per diem if you conform to your pledge under oath, and that's not permissible, but it is permissible to convict an elector for perjury. I'm just that.
Well, that's right, Your Honor, because perjury involves a false statement at the time the pledge is made. In our case, our electors absolutely intended to vote for Hillary Clinton if Hillary Clinton won the election.
I'm not asking about your client. Just stick to the hypothetical, counsel, please.
Okay, but the hypothetical imagines that someone has committed a criminal act. Okay, on the basis of the criminal act, in theory, they could be punished. That's right. But the difference between an elector who gets compensated based on their vote or not based on their vote is a difference driven by the substance of the constitutional discretion that electors are given, the federal function in balloting, the right to vote.
And with respect to the perjury example, could the state remove that individual and not count his vote?
Your Honor, the perjury example does not allow them to remove the individual, no. And what we know in the context of other areas where votes have been tainted, for example, a bribery conviction which involved a vote in Congress, is the vote is not counted. It's just a consequence of the separation between the prosecution and the government.
You indicated to earlier questions that you thought it was fine for a bribed elector to be removed from office prior to voting.
Yeah, I said that if you convict the person prior to the actual voting, then you could remove them if it was...
Okay, the same would be true with perjury, I suppose, then, too? No?
If you could structure the statute and succeed in the conviction. But, of course, the perjury requires, at the time, a false statement.
Thank you, counsel. Justice Kavanaugh?
Thank you, Mr. Chief Justice. Good morning, Mr. Lessig. I want to follow up on Justice Alito's line of questioning and what I might call the avoid chaos principle of judging, which suggests that if it's a close call or tiebreaker, that we shouldn't facilitate or create chaos. And you, I think, answered and said it hasn't happened, but we have to look forward. And just being realistic, judges are going to worry about chaos. So what do you want to say about that?
It's a good thing to consider, Your Honor. And what we've said is, yes, on the one side, you might worry that there's increased risk of, quote, chaos if electors have the discretion we believe they've always had. You suggested the likelihood that is tiny, given it requires electors who are the loyal of the loyal to band together in dozens or, 3 dozen in the last election and flip sides. And, of course, the likelihood of that is extremely small. But what we've also said is there's risk on both sides. The 20th Amendment self-consciously presupposed electoral discretion in the context of the death of a candidate prior to the vote in the Electoral College. And if that happens, but laws like Washington and Colorado ban the exercise of discretion, then the votes from those electors could, in principle, be wasted. And that could throw the decision into the House, and that could flip the result, also unexpected, also potentially creating chaos. So there's chaos both ways, and the number of times we've had candidates die is actually twice as frequently as we've had electors switch their votes and vote for somebody from the other side. So in the face of...
I'm sorry to interrupt. I want to get to another question. You set this up appropriately as, in essence, the states versus the electors in some sense, but isn't it also appropriate to think of this as the voters versus the electors, and that your position would, in essence, potentially disenfranchise voters in the state?
Your Honor, of course, in our case, the action of the electors was to further enfranchise the voters in the case.
As a general theory, I'm sorry to interrupt, wouldn't your position potentially lead to that?
It's potentially true. That's right, Your Honor.
Okay, and then the last question is, the question here is not whether the Constitution requires the states to bind electors. Of course, it's whether the Constitution permits states to bind electors. And on that question, why doesn't the 10th Amendment, as Justice, or the state's authority, pre-existing authority, as Justice Thomas was suggesting, come in?
Well, Your Honor, first, of course, the state doesn't invoke the 10th Amendment, but if it did, it would fail, because whereas in the Thornton case, for example, Justice Thomas could point to traditions that allowed the state to exercise the power that they wanted to exercise there. There is no tradition in America, maybe in the Soviet Union, as Justice Kagan suggests, but not in America, of a government exercising control over a voter, over an elector. That power doesn't exist. Therefore, it's not a question of whether it was taken away by the federal government. It wasn't given. It wasn't there before. And therefore, there is no 10th Amendment power either.
Counsel, thank you. You can take a minute to wrap up if you'd like.
Thank you, Your Honor. The question here has got to both be the constitutional and the pragmatic. And the constitutional question is simply the question whether there is a power in the states which comes from the power to appoint. And there isn't. And it is also the question whether the electors, as electors, the same sort of electors that Article 1 creates, have a discretion. And the discretion is the same discretion which Congresspeople have when they exercise their judgment not to be punished at all under the principles of the Speech and Debate Clause. But there's also a question we acknowledge of the risks. But facing risks on both sides, this court should do what it can do, which is to interpret the Constitution as the Constitution was written, and it has not been amended. Thank you.
Thank you, counsel. General Purcell.
Thank you, Mr. Chief Justice, and may it please the Court. The Constitution gives states the power to appoint electors. That power has always included the power to set conditions of appointment, such as requiring that an elector live in the state or show up for the Electoral College meeting. One condition that states are clearly allowed to impose is that electors promise to support the presidential candidate preferred by the state's voters. States have been choosing electors on that basis since the founding. This court approved that condition in Ray, and the other side admits that states can impose this condition. The only dispute here is whether states can enforce this condition or any other valid condition of appointment. Petitioners say no, or at least that's what they said in their brief. They say that states cannot remove or sanction electors after appointment for any reason, even if the elector is being bribed or blackmailed, even if they lied about their eligibility to serve in the first place, or even if they refuse to show up for the meeting of the Electoral College. That is not the law, as petitioners now seem to acknowledge. Constitutional text, original understanding, historical practice, this court's precedent, all demonstrate that states can enforce valid conditions of appointment like those here. I'd like to start by discussing original understanding because petitioners want you to believe that this case presents a conflict between our country's longstanding practices and the framers' intent. But two stubborn facts refute their claim. First, the framers and their contemporaries clearly understood that states could remove or fine electors after appointment. From even before the 12th Amendment, many states had laws removing or fining electors for violating the conditions of their appointment, repudiating a central premise of petitioner's claim. And second, as this court recognized in Ray and in McPherson, from the very first presidential election, states have been choosing electors specifically because they had promised to support a particular presidential candidate. And this contradicts petitioner's claim that the framers viewed the exercise of discretion as central to the electoral role, and it shows that petitioner's quarrel is not just with our longstanding practice, it is with the framers themselves. Accepting their position would mean concluding that the framers misunderstood the role they had created.
General, could the legislature appoint whomever they want to be an elector?
You know, there's certainly some limits on the discretion. Other constitutional provisions, such as the Equal Protection Clause, impose limits, of course. But in general, states have exclusive authority, as this court has said, to appoint electors and to set conditions of appointment. And certainly,
let's say after they don't appoint electors in any way before the national vote, and then they select the electors that they would like after that vote. Is that all right?
I don't think that's all right, Your Honor. I would need a few more facts to know for certain, but the risk there is that once the state has given to the people the right to vote for president, that right is fundamental, as this court has recognized. So the state legislature cannot override the will of the people by appointing electors to do something different after the fact. So that would not be acceptable. But the state does have the authority to enforce valid conditions of appointment, such as just requiring that an elector show up for the meeting of the Electoral College. And on the other side's view, even that is unacceptable. And as you heard today, I'm somewhat confused about exactly what their position is on this, but it seems they're saying you cannot remove someone even if you know they accepted a bribe unless you can somehow move through the criminal process before the electors meet. And that's just absurd. It's completely contrary to the historical record, and it leads to a dangerous consequence, Your Honor, that there's a huge incentive under the other side's view for those who want to meddle in our presidential elections, whether it be a foreign power or just a wealthy individual, to attempt to bribe or blackmail electors. And it's quite easy to imagine a foreign government hacking into the computer of a few dozen electors to find embarrassing information about them and try to get them to change their votes. And if there's nothing the state can do about that.
I say the state law for electors say that they have to vote for the slate of the party that sponsors them and that they will be certified as electors unless the circumstances after the election have changed to the extent that the legislature thinks the electors ought to be changed. In other words, not unbridled discretion with the legislature, but a condition known to the electors before they were selected. Would that be all right?
Mr. Chief Justice, I think that raises the same challenge as your earlier hypothetical, that while the legislature in the first instance has the power to set any condition that complies with the Constitution, once the legislature has given to the public the power to vote in the presidential election, they cannot override that vote consistent with the Equal Protection Clause in this court's cases. So your hypothetical, I think, pushes up against that principle. And it's not just what commitment are you asking the electors to make, but what have you told the public about their role? And of course, under the other side's theory, the public role, what we currently think of as the presidential election process, the campaigns, the debates, the rallies, the voting, is all irrelevant and always has been. It's purely advisory. And so
all they have to do is tell the public that when it comes to electors, we're going to follow Mr. Lessig's view.
I'm sorry, Mr. Chief Justice, I don't understand the question.
Well, the question is, you're suggesting that the critical factor is whether the state's conduct is based on a condition prior to the selection of electors. And if the electors know that they have the discretion, or that the state has the discretion to replace them, and the people know that, shouldn't that be enough?
No, Mr. Chief Justice, the critical point is that if the condition is constitutional, then the condition can be enforced by removal or by sanction, just as it has been since before 1800. So if the condition is you have to show up for the meeting of the Electoral College, the state can enforce that. If the condition is you have to pledge to vote for the candidate chosen by the state's voters, we know that's a valid condition, the state can enforce it. So that's the crucial.
Also, Justice Thomas?
Yes, thank you, Chief Justice. General Purcell, just to clarify, could you give us precisely some of the limitations on the restrictions that the state can impose on the electors? I understand you can require them to show up for the vote. I understand that you have the limit of what's constitutional, but beyond that, what else limits you?
Well, I think those are meaningful limits, Justice Thomas, and those are the limits. This court has said that the power of states over appointment is exclusive, is plenary. Obviously, as I said, the Equal Protection Clause imposes limits. Other constitutional provisions, like the Presidential Qualifications Clause, impose limits such that states can't, for example, restrict electors' choice of who they can vote for in a way that would violate the Presidential Qualifications Clause. But other than that, states have plenary authority to appoint electors and to set valid conditions. And if a condition is valid, if the condition is constitutional, then the condition can be enforced. That's our position.
Yeah, well, I guess that's why we're here. But one other question: I'm interested in what you think and how you would define the scope of the federal function concept.
Your Honor, I think there's three crucial problems with the other side's federal function argument. The first is that it's just not even supported by the cases they cite. Burroughs and Ray mention federal function in the sense that there is a federal interest, obviously, in the conduct of presidential elections. But they don't say or imply in any way that the supremacy clause restricts state authority over electors. And second, the whole point of the federal function doctrine is to prevent state interference with actions of the federal government and with actions of federal officers. And in this context, the federal government does not elect the president, and electors are not federal officers. And the third point, Your Honor, is the historical one, that if they were right about this federal function idea, then states never, ever would have been able to remove or sanction electors for any reason. And yet we see statutes from even before 1800 in many states that provided for exactly that, for removal or sanction of electors. And under the other side's theory, those statutes have always been unconstitutional. And under the other side's theory, the state can't remove or sanction an elector for any reason, as far as I can tell from their theory. Even if the state knows the person has taken a bribe, the state cannot remove or replace them. Even if the state knows that the person is not going to show up to the meeting of the Electoral College, the state cannot remove or replace them, even though states have been doing that, again, since before 1800. So I just don't understand how the other side's theory is at all consistent with the original understanding. It's just not the original understanding. It's an academic theory that has never been put into practice.
Thank you, counsel. Justice Ginsburg?
What do you make of the fact that Congress has never failed to count an anomalous electoral vote? Not once. It has always accepted the anomalous vote.
Justice Ginsburg, I think that highlights Congress's view that it should defer to states about the votes that they certify to Congress to count. Of course, in every example that the other side's given, the state had certified those votes as the state's votes. But if you look at 2016, Congress also counted the votes from Colorado and from Minnesota, where the state replaced faithless electors with electors who promised to vote as pledged and did vote as pledged, and Congress counted those votes as well. So what you see in the history is Congress deferring to the state's designation of which electors are validly appointed by the state.
Thank you.
Justice Breyer?
Thank you, counsel. I'd like you to assume whether this is Mr. Lessig's argument or not. Assume this is my argument for present purposes. The only thing a state cannot do is to punish the elector for the way he actually casts his vote. As far as bribery laws are concerned, there are plenty. As far as gratuities, all kinds of things, what he's doing before he'd accept a bribe or promise to before. The only thing is the actual casting of the vote. Now there, as to that, what would happen, and there have been quite a few faithless electors, for the most part, it hasn't mattered. Where it really might matter is if somebody died or some catastrophe happened or worse. There it might matter. And in the one case, Congress refused to count votes which were cast for the person who was promised, Horace Greeley. And so there is a mechanism in Congress to protect catastrophe, namely, they count which ballots they choose to count. The alternative is your alternative, which is the state tries to control it, which is the greater danger, which is the greater safeguard. To have a Congress that will decide what to do with the faithless electoral vote, or to have the state, possibly, who knows what they could pass as a requirement. Now, what is your opinion about that?
Well, Justice Breyer, there's a lot there, and I want to start by addressing your last question about what can Congress do. Congress cannot solve this problem because Congress cannot appoint an elector for a state. So even if Congress could reject a ballot, for example, if it knew that the elector had been bribed, the state has lost that electoral vote and cannot get it back. The Congress cannot appoint a new elector for the state. And just rejecting that ballot might alter the outcome of the presidential election, or rejecting several ballots might. The idea that Congress can solve this after the fact it's not true, and it ignores the constitutional delegation of power to the states. Turning to your other points, I mean, there's just no, an example I think helps illustrate why there's really no constitutional difference between failing to show up and failing to keep your promise. So imagine two electors who both do not like the nominee who eventually wins their party's nomination and wins the general election. One says, I'm not going to show up for the Electoral College meeting because I don't like this person. The other says, I'm going to show up and I'm going to vote for someone else. Both have violated valid conditions of their appointment. Both can be removed and replaced by the state, and there's no constitutional problem with that. There
is a difference between the two. In the one case, your state is punishing the person for what he does before voting. In the other case, he is punishing him for the way he casts his vote. And that is what I think the other side says is the one thing the state cannot do.
First of all, Justice Breyer, Washington's revised law now removes the person before they can vote, just as Colorado's law does. Washington's prior law did impose a fine for breaking your pledge, for violating the condition of appointment. And there's nothing wrong with that. If you look historically, from even before 1800, states had fines for violating conditions of appointment. And so, and it's also quite common for appointed officials at the state and federal level to potentially face consequences for voting in violation of a promise. So, for example, the United States ambassador to the UN certainly has a vote in the UN General Assembly. But if they vote different from how the president directs them, the president, of course, can sanction them or remove them. So it's quite common with appointed officials that they can face consequences for voting differently than they promise. And that's what this is just a straightforward example of.
Thank you very much.
Justice Alito?
Hey, counsel, does the Constitution impose any limits on a state's power to attach conditions to the appointment of an elector?
Some, Justice Alito, the ones I was referencing earlier. So obviously the state cannot impose conditions that themselves would be unconstitutional, such as race-based conditions, for example. Okay. But sorry, go ahead.
What else?
Well, as I said before, the state can't impose conditions that would violate the Presidential Qualifications Clause. Other constitutional limitations might come into play if the, it's hard to imagine but our basic point is that if a condition is constitutional, and we know this condition is, then that condition can be enforced. That's the key question, is the condition itself constitutional?
Could a state require electors to cast their votes for the candidate chosen in a resolution passed by the state legislature after the popular vote is cast?
No, Your Honor. That's what I was trying to say in answer to the Chief Justice's question as well. That would violate the public's fundamental right to vote once they've been granted that right by the state, and violate their fundamental right to vote.
Well, I didn't quite understand that answer. Is a state obligated to choose electors through popular vote?
No, Your Honor. As at the beginning, in the early days, the legislature can choose electors directly if it wants, and in that circumstance, the legislature can impose and enforce a pledge. But once the legislature has given the power to vote to the public now has a fundamental right to vote and have their votes counted equally. And as this court has said in a number of cases, and so the legislature can't then override that vote after the fact.
Why is that so? Could Washington say, we're going to choose 12 wise people to be our electors, and we are going to allow the public to advise them through a popular vote to give them the sense of what the people of Washington want? Would that be unconstitutional?
If the legislature made clear that the public vote was entirely advisory, then I think that presents a tough question. But I think they probably could do that. The key compromise of the Constitution as to electors was to leave it to states to decide exactly what authority they would have. States were free to decide to leave electors with discretion, as some states did then, and as some states still do today. But states were also free to choose electors on the basis of who they had pledged to support as many states did from the beginning, and as the majority of states do now.
What is the difference between that setup and the setup that Mr. Lessig says is required?
Well, Your Honor, the crucial difference is that Lessig is saying there's nothing the states can do to remove or sanction electors after appointment for any reason. And we are saying that we know from history and we know from Ray, and the other side even admits that this condition of pledging to support the candidate preferred by the state's voters is a constitutional condition. And that condition can be enforced just like any other constitutional condition. That's the key. That's our key point. And states have been removing and replacing electors for violating conditions of appointment since before 1800. States have been choosing electors specifically because of who they pledged to support since the very beginning. If the other side were right about how electors were supposed to operate, what you would have seen historically is electors trying to convince legislatures and the public to choose them because of their great wisdom and knowledge. They would have been saying, choose me, I will decide well on your behalf. And that is never, ever how American presidential elections have operated. Electors were chosen because of the candidate they had promised to support. So to adopt their view would be to radically change how American presidential elections have always operated.
Justice Sotomayor?
Counsel, I'm curious about your views on the 10th Amendment. The other side points out that you never raised it. Two of my colleagues have referred to it. But am I assuming correctly that Thornton sort of puts a quash on relying on the 10th Amendment in a situation like this? This is a new procedure that Congress intended. So the states can't say that they expected or reserved a right in something they never knew they had.
Well, Your Honor, we didn't explicitly argue the 10th Amendment, but we don't think we need to rely on it, and we support our colleagues in Colorado in making that argument. We think that the fundamental premise of the Constitution is that states have, the federal government is one of enumerated powers. States have powers unless they're taken away. Nothing in the Constitution restricts state authority to impose conditions on appointment of electors and to enforce them. And even if that weren't the case, the text itself gives states power to appoint electors. That phrase, this court has repeatedly said, the appointment power, inherent in that power is the removal power unless there's contrary language. And the original understanding has always been that the appointment power of electors included removal power, as you see in the early statutes. So I don't think the court needs to rely on the 10th Amendment to resolve this case. I think, but I think it's certainly the background principle that states have powers unless they're limited by the federal Constitution is relevant and supports our side.
Now, you rely on a default rule in your brief, which you haven't mentioned yet, which is the power to appoint includes the power to remove. But all of the examples that you rely on are vertical appointments, when an official within one branch of government appoints a subordinate in the same branch for an indefinite period. And the idea is, if I appoint you, I should be able to get rid of you if in your service to me, you are doing something wrong. But here, the state is appointing a voter to do something that most people think of as requiring judgment and some measure of freedom, which is the power to cast a ballot. The other side in its brief points out that there were other words that would have connoted something different than elector, like a delegate. You appoint the delegate to cast the vote for you. But that's not what Congress chose. In appointing an elector has a sense of someone who's going to vote. So how can you say that that tradition within the executive branch of the power to remove is controlling here?
Justice Sotomayor, there's really three fundamental problems with the electors' argument on that front. There's a textual problem, a historical problem.
I don't think it's their problem. I think it's your problem.
Well, I guess I'd say none of the cases say anything like what they have drawn this vertical appointment language. Well, first of all, it first appears in their reply brief. In their opening brief, they said that rule, well, they didn't mention the default rule at all. They suggested it was just the executive branch. And then in our response, we pointed out, well, actually, there's a bunch of cases from the judicial branch applying this rule. And now they've invented this kind of vertical rule, but that rule appears nowhere in the court's cases. The court has said in context after context that the removal power is inherent in, it just comes along with the appointment power. You said it in constitutional cases, statutory cases, high-level officials, low-level officials, judicial branch, executive branch. And even if you hadn't said that over and over again, if you look at the history, here the history shows that states could remove electors from the very beginning. Again, from the statutes from before 1800. And the other side's theory on this front also is that once the state appoints the elector, they somehow become part of another branch of government or something like that. But the court has rejected that idea. The court has said that these electors are not federal agents or officials. The court said that very clearly in Fitzgerald over a century ago. So their newfound theory about so-called horizontal appointments, it's just not supported by text, by history, or by precedent, and it's kind of a sideshow. Frankly, it's just not. It doesn't help answer the question here. The court has never drawn that distinction.
Thank you, counsel. Justice Kagan?
General, what do you view as your best textual argument?
Well, Your Honor, we think the best textual argument is just that nothing in the Constitution limits state authority over how to appoint electors or whether states can impose conditions and enforce them. We think there's a direct grant of authority in the appointment power, as this court has repeatedly recognized. And we think that certainly by the time of the 12th Amendment, everyone understood that electors were being chosen in the states because they had promised to support particular candidates. So the idea that when the framers of that amendment used the word elector, they inherently meant someone who can exercise discretion, it just doesn't make any sense. That is not how the term was being applied in any of the states. That was not how they understood it. And in fact, the framers of the 12th Amendment quite clearly intended to embrace the system as it had developed, where electors were pledging their votes and states were choosing them on that basis. This court said that in Ray very clearly. That was a key point of the 12th Amendment. So,
if I understand you correctly, you're really saying you don't have an affirmative textual argument. What your argument is that the Constitution doesn't say, and if the Constitution doesn't say, we should presume that states were meant to decide.
Well, let me be more precise, Justice Kagan. Well, I think that starting principle is right, that should be the other side's burden to show that we can't do this. But the power to appoint does include the power to remove it. So there is a textual grant. And what I was getting at the end there was just that the central premise of the other side's argument is that these words, elector, especially elector, require the exercise of discretion. And that's not true as a textual matter, and it's absolutely not true as a historical matter. And so that's, I guess, the point that I was trying to get at there was that it's their argument, really, that asks you to ignore the original understanding and early practice, and they're asking you to do that based on words that, meanings of these words that just are...
It includes the power to remove highly contextual, but it depends on a certain understanding of control, which is exactly the question here. You're sort of assuming the conclusion by saying that.
I disagree, Your Honor. The court has said repeatedly that the power to appoint includes the power to remove unless there is text limiting that power, and that limitations on the power, the court has said, will not be implied. And again, the court has said that in many, many, many contexts, and really the only time the court has found otherwise is where there was explicit text limiting the removal power. And so I don't want to overly emphasize this point. I think it's at least as important that when you look at the early understanding, the framers and their contemporaries clearly understood that states could remove and replace electors, and they also clearly understood that states could choose electors because of who they had pledged to support. So, I think it's the other side that really is asking you to rip these words out of context and place vastly more weight on them, on these kind of dictionary definitions, untethered from how the framers actually applied them. They're asking you to adopt kind of one possible reading that the framers could have had of these terms, but it's a possible reading that is just refuted by what the framers and their contemporaries actually did. And it also, Your Honor, Justice Kagan, it leads to the absurd consequence that everything that we think of as the presidential election process currently is really just advisory. It is all largely irrelevant. It just all that matters is who the electors choose. And on the other side, it's telling they can choose whoever they want for whatever reason they want, and they can't be removed even if they're taking a bribe, or even if they're being blackmailed, or even if they say in advance, I'm not going to show up for the meeting. it just, again, it would radically change how American presidential elections have always worked in our country.
Thank you, General.
Justice Gorsuch?
Counsel, I understand your argument is that a $1,000 fine doesn't diminish or negate the fact that the elector here is voting and has, in some real sense, a right to vote that's being honored. But what about the new law that both Washington's adopted and I know Colorado has too, the Uniform Faithful Presidential Electors Act? And I know you're going to tell me it's not before us, but put that aside for the moment, if you will, for purposes of this question. That, as I understand it, and you can correct me, that if an elector renders a faithless vote, that automatically removes him from office as a matter of law, and in fact, votes aren't even counted until the Secretary of State has collected the requisite number of ballots marked for the right people based on pre-existing pledges. Is that consistent with the Constitution's prescribed order of appointment, meeting, and voting? It seems like the voting comes first and then the appointment under the uniform law. And is it also consistent with the Federal Electoral Count Act? If you could just speak to me about those questions, I'd be grateful.
Certainly, Justice Gorsuch, it is consistent because the way that the laws work is that the elector who seeks to violate the conditions of their appointment, like casting a faithless ballot, is removed before they can vote. They're not removed before they're appointed. They are initially appointed, but then they're removed when they violate the condition. And then they're replaced, and another elector is appointed who will follow the law that they promised to follow and keep their promise and vote as directed. So the order is proper. It's an appointment, and depending when in the process the elector announces their intentions, they're removed and they're replaced by someone else who votes in accordance with state law. And to come back to my example from earlier, if I can, there's really no meaningful difference between the person who says, I don't like our nominee, I'm not showing up for the meeting, and one who says, I don't like our nominee, I'm showing up for the meeting, and I'm voting for somebody else. The state, both people have violated valid conditions of appointment. Both people can be removed by the state and replaced by someone else. The other side's position is neither of those people can be replaced. And even the person who says, I'm not showing up because somebody gave me $2 million to not show up because that might affect the outcome of the election, the other side says that person can't be replaced. That just makes absolutely no sense historically, textually, or practically.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, General Purcell. If you're right about the electors not having this kind of discretion from the Constitution, I wanted to get your take on provision of Article 2, Section 1 that says no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. What is the purpose you see of that provision if your theory of the electors is correct?
Yes, Justice Kavanaugh, thank you for that question. So the framers did not spend a whole lot of time talking about the exact role of electors, and they certainly did not agree on exactly what role they would play, but one thing that they were clear on was they did not want Congress choosing the president. And so they specifically prohibited members of Congress from serving in that role, but they left it to states to decide whether electors would serve as kind of, as Hamilton envisioned them, as the kind of sage chooser on behalf of the state, or as many other framers wanted, the electors to be agents of the people, to act on the people's behalf, and for the people to choose them and for them to be bound to that outcome, to be bound to the people's preference. So yes, they imposed that limited limitation on who could serve, and that is, another example of a constitutional condition limiting state authority. But again, it just goes to the point that if the state can set a condition to serve as an elector, that condition can be enforced.
Mr. Lessig says that the framers considered various modes, obviously, and you agree, and history shows they considered the states doing it directly, or at least that was an idea out there through the legislatures or governors. They considered Congress, as you just pointed out, but there was a separation of powers there, problem there. They didn't necessarily want the new president to be too dependent on Congress. Popular election was was not adopted, and so they came up instead with what Mr. Lessig describes as a indirect mode of selection with the model of electors who would exercise, as he sees it, their own discretion and independent judgment to pick the best person to be president, the best person to head the executive branch. And he says that mode remains indirect, consistent with the framers' choice, only if the electors retain a legal discretion. So on that overall structure that Mr. Lessig sets up and describes the history, why is he not right, given that they rejected all these other modes?
Well, the framers had a number of concerns about direct elections that included logistical concerns and concerns about the impact on the influence of southern states. But ultimately, they settled on an approach that left it to the states to decide, as this court said in McPherson, the broadest possible power of determination as to how to appoint electors and what role they would play. And the options open to states certainly included both leaving electors with discretion, as some states still do today, and states choosing electors specifically because they had pledged to support particular candidates. And certainly by the time of the 12th Amendment, that had become the virtually universal practice in states. And the framers of the 12th Amendment well understood that and adopted the language of the 12th Amendment to facilitate that. And if you need a historical example, if that would be helpful, in the election of 1804, right after adoption of the 12th Amendment, it operated just as they had expected. The parties put forward presidential and vice presidential tickets. Electors were chosen throughout the country because they supported those tickets, and every single elector in the country voted for the party ticket preferred by their state's voters. And the meetings of the electors, even in 1804, were in many states mere formalities. They filled out pre-prepared ballots. They did not discuss or deliberate, and Congress did not question a single one of those ballots or their validity. So that just shows that by the time of the 12th Amendment, as this court has said repeatedly, the role of electors was simply to transmit the vote of the state for president.
Thank you.
Thank you, counsel. Would you like to take a minute to wrap up?
Yes, thank you, Mr. Chief. Thank you, Mr. Chief Justice. Every 4 years, over 100 million Americans participate in our country's presidential election process. They attend rallies, they watch debates, and ultimately they go to the polls. More Americans participate in this election than in any other democratic process in our system of government. But under petitioner's theory, this entire process is irrelevant and always has been, because all that matters is who the electors prefer. On their view, the electors can choose whoever they want to be president, regardless of any voluntary commitments they made to secure their position, regardless of how their state voted, and regardless of whether they are being bribed or blackmailed for their vote. That is not the law. The Constitution's text, the original understanding, this court's precedent, and our country's historical practice all demonstrate that states are allowed to require presidential electors to vote for the candidate chosen by the state's voters and to enforce that requirement. We ask you to reaffirm that principle today. Thank you.
Thank you, General. Mr. Lessig, you have 2 minutes for rebuttal.
Thank you, Mr. Chief Justice. The state has relied upon early statutes, which it says affirm the power of the state to remove electors because they violate a condition. Absolutely none of those statutes had anything to do with the conditions on voting. Those statutes related to the appointment power. They were incidental to the appointment power. So we concede, obviously, that incidental to the appointment power, the state has the authority to make sure someone shows up to vote. And we believe that general laws apply to electors as well. This is not a general immunity. But they have no power to control the vote, and they never have exercised that. The state has asserted that because they appoint the electors, they get to control the electors. But in fact, the authority they rely on is quite explicit. Myers, at page 119, says the reason for this is that those in charge of and responsible for administering functions of government need the authority to control them by removing them. That was the reason for the principle. But there is nothing in the founding to suggest that the framers imagined the states administering the Electoral College. That's why the states don't appear in the 12th Amendment at all. And finally, Your Honor, if you recognize this power, how will you cabinet? If you find a state has the power to regulate electoral votes, may the state forbid the elector from voting for a candidate who has not visited the state, who has not released his tax returns, as bills in New Jersey and New York purport to do, or is not pledged to appoint justices who will uphold Rome. Open this door, and there are an endless list of partisan opportunisms that will tempt the states. Throughout history, there have been amendments to change the elector discretion every single time, recognizing there was that discretion. For the state of Washington in 1977 to discover it is to show they were chumps believing they didn't have this power. And we believe the power has always been with electors to exercise discretion. Thank you, Your Honor.
Thank you, counsel. The case is submitted. We'll hear argument next in case number 19-518, the Colorado Department of State versus Michael Baca. I note at the outset that Justice Sotomayor is recused in this case. General Weiser.
Thank you, Mr. Chief Justice, and may it please the Court. The Constitution authorizes states to use their plenary authority to remove a bribed elector, one who engages in a rebellion, or one who would perpetrate a bait and switch on the people of their state by voting contrary to a binding pledge. By contrast, if the state wishes to treat electors as free agents rather than as proxy voters, it is free to do so. In short, states determine how to select electors and ensure that they meet the relevant requirements and perform their duties as assigned. This means, under Green, that states can oversee bribery as an incident has a power to appoint. This must include the power to remove an elector without requiring a full criminal trial. Under my friend Mr. Lessig's position, as a practicality, bribe electors would cast ballots and illegal votes. In this case, the state prevented Mr. Baca from casting an illegal ballot, just like it's an illegal ballot if you don't sign it here in Colorado. As this court explained in Ray, the purpose and history of the 12th Amendment reflected the reality that electors acted as pledged agents for their political parties, and the history of such pledges should be given great weight. As to Justice Ginsburg's point about the importance of enforcing a pledge requirement, it's worth noting people rely on such pledges, which are taken voluntarily, and as Justice Scalia explained in the Intertribal Council case, voting requirements would be of little value if not enforced. In the almost 70 years since Ray, states have continued to enact laws to enforce elector pledges. Congress has consistently deferred to the state's plenary authority, and no court other than the 10th Circuit below has invalidated a pledge-binding law. Mr. Chief Justice, I would welcome your questions.
Well, my first question is to ask if there is anything that General Purcell said on behalf of the state of Washington with which you disagree.
Thank you so much, Mr. Chief Justice. I would only add a slight wrinkle. He did indeed endorse our 10th Amendment argument. What I would say on that is the 10th Amendment is an important interpretive principle because the Constitution gave the states authority over elections. The 10th Amendment underscores that point.
Would you state for me exactly what you think the limits on the state power to replace electors are?
Your Honor, here I would echo my colleague from Washington. It governs whether or not another constitutional provision is violated. The 14th Amendment quite notably means a state could not remove an elector based on race or religion. Also, the qualifications clause means you can't remove electors for the purpose of adding qualifications for who can be president.
So if you selected electors, one of the requirements is they had to be relatives of the legislators, that would be all right?
Your Honor, here in Colorado, we picked electors in 1976. The state legislature did it directly. As long as that choice doesn't violate a constitutional provision, they can pick whoever they want.
What if the rule is, you know, the electors are chosen pursuant to slate, but anyone who says anything disloyal to the state between the time where they're selected and the time they cast their vote will be replaced?
Your Honor, as my colleague from Washington noted, once people are voting to make a choice, people have a right for their ballots to be counted. And here, in the hypothetical you just noted, the ballots of people would be invalidated after the fact. That implicates Gray versus Sanders and this court's line of right-to-vote cases.
Any other limitations on the power of the state? What about the bribery cases that have been, or bribery hypotheticals that have been discussed?
Thank you, Mr. Chief Justice. The ability to remove bribed electors is crucial for the states to have, and not only after a criminal trial, but after there's a basis for this concern. To your point, if a state failed to remove a bribed elector, the state would not have violated a constitutional provision per se. It would have violated its duty as a sound overseer of presidential elections.
That's even after the electors have been chosen. In other words, go ahead.
Mr. Chief Justice, the state is indeed authorized to remove electors who've taken a bribe, if that's your question.
Yes. What about your power to appoint argument? It does seem, certainly our cases involving the power to appoint by executive officials or the president do say that it carries with it the power to remove. But that has always been with respect to inferior officers. And the electors here, it seems to me, are not inferior in any way to the state legislature. They carry rights as appointees carrying out federal responsibilities as well. So I don't see how those authorities support your position.
Your Honor, we disagree. The Constitution clearly gives states plenary power over electors and as acting as a steward of the presidential election system. That means if electors were to take a bribe, for example, or not to show up, it's on the state to address that point. If you only left this to Congress in the final instance, that would mean that all Congress could do is remove the elector and not have it be counted. What the states can do is replace an elector and make sure that the state has the constitutionally authorized votes in the Electoral College. As such, the states play a critical role, and that role includes the power to remove.
Thank you, General. Justice Thomas?
Thank you, Mr. Chief Justice. General, you start your brief questioning standing in this case. I wonder if you think under our precedent they're standing when a person is removed from an elected office.
Your Honor, the past cases involving removal from an elected office, like Powell, for example, involve an official with a salary. What's unique here is there's no salary or other personal injury. What's at issue here is the institutional role itself. And as this court made clear in Smith and a line of cases, an individual doesn't have standing to challenge the institutional role that he or she may believe is unconstitutional.
So in a removal case, at what point do you think there would be an injury in fact?
Justice Thomas, insofar as someone gives up a salary like in Humphrey's executor, you have injury in fact. If it is an honorary position, a volunteer position, there's no personal injury. There's merely a quarrel with the institutional role.
On a separate issue, you know, throughout, I guess, our history, there have been pledges among electors. But can you point out the first state law that required pledges in our history?
I can, Justice Thomas. It was Oregon that did so in the late 19-teens. And what I want to underscore is that wasn't the first time an elector was removed for violating a pledge. In 1912, Nebraska, without any elector binding law, did remove an elector who had promised to violate the pledge because the court, in that case, the Nebraska Supreme Court, said it would have been a fraud on the people of Nebraska.
You attach yourself to the arguments of General Purcell, so I do want you I understood his comments on the federal scope of the federal function concept or argument. Could you give me what your take is on that?
With pleasure, Justice Thomas. Our view is that doctrine doesn't really fit here. Under the Constitution, it's the role of the states as stewards overseeing the presidential election process. The typical federal function case, like McCulloch versus Maryland, you're worried about a state interfering with a federal official. Here, as this court has made clear multiple times, electors are not federal officials. They are appointed by and overseen and transmit the vote of the states.
Thank you, General.
Justice Ginsburg?
Can you give us an idea of the practical consequences of a ruling one way or another? How would a ruling against you actually alter our democratic processes? Most states already require elector pledges. And faithless voting throughout the years has always been rare. So how much difference does it make?
Your Honor, the chaos that could result from upholding the 10th Circuit's ruling is one that could occasion a constitutional crisis. As was noted by my colleague from Washington, if states have no ability to remove bribed electors, and all that's left is Congress's ability to choose to count or not count, the mere fact of bribing electors in an open enough way would knock out electors, would limit who could vote, and ultimately could sway the outcome of a presidential election. It's the role of the states to oversee confidence in our election systems, to ensure that the public's voice is heard. And all of those values, the integrity of our elections, are at stake in this case.
Returning to the standing question, Baca was removed from his post. Isn't that a stigma, at least? Why isn't it, may not have economic consequences, but isn't it a blot on his reputation? And wouldn't that constitute a cognizable injury?
Your Honor, the auditor in Smith believed that he suffered a stigma having to implement an unconstitutional statute, and that concern of his stigma was not sufficient to give him standing. I would submit the same rule holds here.
Thank you.
Justice Breyer?
A technical question. This is a lawsuit brought against you, the state, under Section 1983. The court's opinions, I take it, have made clear that a state isn't a person under 1983. Now, everybody's waived that argument. Both sides would like us to rule, but can they? If someone sues a foreign country under 1983, and a foreign country can't be a defendant under 1983, can the parties simply get an opinion from this court by waiving the question?
Your Honor, I would start with Justice Ginsburg's opinion in the Northwest Airlines case, where she made plain that whether or not there's a claim for relief in a statute is not a jurisdictional question. What we're dealing with here, both under Section 1983 and 11th Amendment immunity, is strategic decisions made by our state in the course of litigation. We made those decisions because we wanted to litigate this case on the merits. We believe we have a case on the merits and standing, and that's how we've chosen to proceed.
Oh, yes, but that isn't my question. My question is, of course you want a decision from this court. But Mr. Smith might want a decision about how the Constitution applies to someone in Mexico or to someone in Russia. I mean, can the parties get that advisory decision by simply saying, oh, we waive all the jurisdictional problems, all the non-jurisdictional problems, all the problems that say this statute doesn't apply?
Justice Breyer, this court will opt for whatever ground it chooses. With respect to whether the court has to rule on this issue, the answer is no. This is not a jurisdictional question. For us, this was one of several strategic questions on what grounds to litigate.
I got it. The other question I have is, I take it that it's only in 1960 that the first state passed a statute that actually removed or punished a person for voting the wrong way, an elector. So were there cases of bribery that went unpunished before 1960? And was there a single case? If so, how many? And what happened? Were their votes counted, although they were bribed?
Justice Breyer, the first statute was in the late 19-teens in Oregon, but before that there were
a statute which required a pledge that didn't punish people for how they voted. But regardless, same point.
Your Honor, we don't have a history of what types of changes were made. What we know is they happened all the time. As Professor Hardaway notes in his brief, for example, in Michigan, there were electors who just didn't show up, who then were replaced on the day that the Electoral College had to meet. We haven't had electors who are upset about having been replaced or not counted.
That isn't my question. My question has to do with bribery. And before the first statute was passed, more than 200 years after the Constitution was first created, were there instances of an elector being bribed? And if so, how was it handled?
We don't know of any such instances, Your Honor.
Thank you.
Justice Alito?
In past elections, were there concerted campaigns to influence electors after the popular vote was cast for the purpose of either reversing the result that was produced in the Electoral College by the popular vote or throwing the case into Congress?
Justice Alito, the most famous such case would have been in 1876 involving the Tilden-Hayes disputed election.
My other question is essentially the same one that concerns me with respect to the positions of all the counsel in these two cases, and that is limitation, if any, on the arguments that are being made. So is it your position that a state has plenary power to remove an elector? If not, under what circumstances can an elector not be removed?
Your Honor, from McPherson, we do see plenary authority, oversight, and removal power of electors, and the constraint on that is other independent constitutional conditions, such as ones we've discussed previously under the 14th Amendment, for example.
So suppose the legislature is in the hands of a political party other than the party of the candidate who wins the popular vote in the state. Can the legislature simply remove all of the electors who were pledged to vote for that candidate and replace them with other electors?
Justice Alito, this is an important point. Let me first answer your question, then get to a slightly different one that raises the same concern. If the legislature announces the procedure in advance and gives people the right to vote, and they exercise that right, the legislature cannot undo the public's right to vote without violating the right to vote line of cases. However, if the legislature acted earlier, say the prior spring, to change the process to give itself the power to appoint electors, not the power in the hands of the people, that's a choice state legislatures could make. In McPherson, it was litigated whether or not a legislature could move from a winner-take-all to a districting system. There was a partisan motivation for that change, and the court said the legislature's power was plenary.
Well, if we agree with you that the legislature has plenary power to remove electors, then won't the people of your state understand when they cast their vote for president that the legislature has the power to remove the electors pledged to the candidate they favor and replace those electors with other electors?
Justice Alito, what we're asking for, what we believe the right to vote cases require, is that the public be told what they're voting on. Per the Chief Justice's earlier question, if the public is told you are merely casting an advisory vote as opposed to a binding one that you can expect will be followed, that's a different case.
What is the best right to vote case that stands for that principle?
In Gray versus Sanders, it says the public has a right for their ballots to be counted.
Thank you, counsel. Justice Kagan?
General Weiser, first on your 10th Amendment point, why doesn't Thornton foreclose that argument? Thornton said that the 10th Amendment reserves only those powers that the states held prior to the ratification of the Constitution. I would think that the power we're talking about here is not such a power, but instead was created by the Constitution in the first instance. So how can the 10th Amendment support you consistent with Thornton?
Thank you, Justice Kagan. What I would suggest here is a similar principle to what Justice Kavanaugh articulated earlier. Justice Kavanaugh noted the chaos principle means if you have a close case, you avoid creating chaos. We would say if you have a close case, you avoid intruding on federalism concerns, and that's grounded and represented by the 10th Amendment.
But again, I thought that that was only as to the powers that the states held prior to the ratification of the Constitution.
Your Honor, as a strict matter, that is what the 10th Amendment does, but there's also the interpretive principle picked up, for example, in Gregory versus Ashcroft that says when looking at intrusions on state power, limits on state power given to the feds, you do so lightly.
Okay, Mr. Lessig ended his argument by giving a number of hypotheticals. He said, you know, if a state can do what you're doing, a state can also say enforce pledges to vote only for candidates who have visited the state or who release their tax returns or who take a position on certain issues. Is that right?
Not necessarily, Your Honor. The tax returns issue has been litigated under the qualifications clause in California, and the court there said that did constitute adding a qualification to be president. But moreover, I would note there's also an independent question about whether or not you could have a state saying, we won't allow someone to be on our ballot in the state at all if they haven't done X, Y, and Z. And indeed, in the California case, it was not in the elector context, but in the access to the ballot context that the issue arose.
And if you're relying on the qualifications clause, couldn't you be said to be imposing a qualification too? In other words, that the candidate actually have received more votes than anybody else in your state?
Respectfully, Your Honor, I wouldn't interpret that as a qualification to be president, particularly because the right of the states to have a system where the people could be heard is part of the original constitutional design, and then, again, confirmed in the 12th Amendment itself.
Well, it sort of assumes the conclusion. I mean, it's obviously a pretty normal understanding of what elections do, but if you assume that these electors were meant to use their own discretion, then the popular vote was not required, and it would be imposing a qualification.
Your Honor, if you assume electors have this discretion, you've assumed the answer to this case. We would say they don't have that discretion at all.
Exactly, but you're assuming the answer in the exact same way, aren't you? What is or is not a qualification sort of depends on this case. So I don't think that you can get rid of Mr. Lessig so easily as you would like to.
Your Honor, our position is that the Constitution is silent on whether or not you can have electors representing how the public votes. That is inherent in this design, and thus we say what's inherent in design couldn't be an additional qualification.
Thank you, counsel. Justice Gorsuch?
Counsel, I'd like to continue the same line of questioning that Justice Kagan raised with you and Mr. Lessig suggested. If states enjoy plenary power to remove electors, what would prohibit them from passing a law, for example, to say that all electors have to vote for presidential candidates who support certain positions, or who have done certain things, or who have visited the state? Now, I understand your ex post argument, that is, states can't change the rules of the election after the election and have to provide voters notice, but if they did it well in advance, what would prohibit them from doing so, if anything, on your view?
Your Honor, I'm trying to square how this fits with a popular vote system, because if you give people the power to vote and they exercise the power, then our argument is you count their votes. What I believe you'd be getting at would then be a pre-clearance process where you'd have to pre-clear what electors could be on the ballot before people could vote on them. In that system...
Just to interrupt you, I'm sorry, counsel, but you've indicated it'd be fine for people to have an advisory vote to 12 wise people who would then make the final decision. Why couldn't you also have a system in which the people provide advice within certain parameters set by the legislature?
Your Honor, I think that's the same context I had in mind, which is you would basically give people an advisory vote, and then after the fact, you'd have to ask...
No, not after the fact. They've been alerted prior to the fact, counsel. That's my hypothetical. I understand your point about after the fact. In advance, they've been notified that they are free to provide advice to 12 electors, or whatever the number may be. And their advice, though, is going to be bounded. And there are certain things that the electors have to because the legislature says abide by, or else they'll be removed. And those are, again, as the presidential candidate visited the state, has he taken this or that position? Has he or she, turned over her tax returns? Whatever the conditions may be. It's a bounded choice. You've been arguing that choice can be bounded, and this is just another bounds. What prohibits the state from doing that?
In this situation, the state can add limitations as long as they comply with other constitutional provisions.
And do those?
The requirement to visit a state, I don't believe, clearly violates any constitutional provision. The tax return issue, we've noted, raises a qualification clause question that could be a real concern. And
no, the presidential candidate is on the ballot. It's who the electors can vote for. Is that a qualifications problem in the state's view?
Yes, it would be, because if you tell electors they can only vote for pick whatever the concern would be. Tax returns, people over 50. The concern is you could be adding a new qualification to be president and thereby disqualify, in effect, someone from being president who the Constitution would qualify to be president.
How about political positions, or you say visiting the state, that's permissible, that condition would be permissible in your view?
Your Honor, I don't see off the top of my head any other constitutional constraint that would address that issue. Our position is the power is plenary or exclusive, as this court said in McPherson. The state can oversee electors and remove them who don't follow requirements the state deems appropriate.
Thank you. Thank you, counsel. Justice Kavanaugh.
Thank you, Chief Justice. Good morning, General. What is the purpose of having electors?
Thank you for that question, Justice Kavanaugh. When electors are set up in the constitutional design, that allows for states to make a choice. Electors can either vote as proxy voters on behalf of the public, as we do here in Colorado, or they can be free agents. By having this structure uniform across the several states, you give states the ability to choose which model they want.
But wouldn't, if that were the design, why not just leave it to the states as opposed to going through all these details about how the electors are supposed to operate? As you know, Justice Jackson and Ray, looking at that history, said no one faithful to our history can deny that the plan originally contemplated was that electors would be free agents to exercise an independent and nonpartisan judgment as to the people best qualified for the nation's highest offices. That's the end quote from Justice Jackson. So that implies not a choice, but actually a requirement that the states give this kind of independence, free agent status to electors. And why go through all the details if it's the way? I guess what I'm asking more broadly is the text has all these details to set up a design that seems closer to what Justice Jackson articulates. Where in the text do you hang your hat?
Your Honor, our textual hook is the delegation of the authority to the states. By contrast to what Justice Jackson said, James Madison said the Electoral College was all about giving the states authority to oversee presidential elections as they saw fit. And as the majority in Ray noted, contemporaries of the founders did indeed see electors as proxy voters on behalf of the public. And that was absolutely the backdrop to the 12th Amendment. So I would also point you to the 12th Amendment as effectively confirming and accepting the fact that electors can be, indeed most often are, proxy voters, not free agents.
Why do you think the founders did not leave it up to the states to decide whether they wanted their members of Congress to be electors?
Your Honor, the Constitution had a series of compromises between separating powers between the states and the federal government and between the states. This was one of those compromises that was reached at the final days of the Constitutional Convention.
Thank you.
Thank you, counsel. You have a minute to wrap up if you'd like.
Yes, Mr. Chief Justice, as we've noted, this case is all about state authority. And on the theory of my friends on the other side, states have no authority even to remove bribed electors short of a full criminal trial. Our founders gave the states this authority, expected them to exercise it in ways that were sound. That's what has been the history of our presidential elections. We would urge the 10th Circuit decision to be reversed.
Thank you, counsel. Mr. Harrow.
Mr. Chief Justice, and may it please the Court. This case is about a trade-off between flexibility and rigidity. The state's rule is too rigid, and that rigidity could come at a steep cost. The state's binding law has no exception. If a candidate dies between the popular vote and the vote of the electors, there is no exception. If a candidate has a stroke, there is no exception. If there is widely recognized fraud or bribery by the candidate, no exception. If there will be a tied electoral vote and a potentially deadlocked House, no exception. The law is rigid. Electors vote for the winner of the popular vote in the state, or, well, there is no or, Your Honors. That's the only option. that rigidity has no place in our constitutional universe. If something goes awry in this coming election or any other, the framers thought that electors could vote with discretion, and the 12th Amendment didn't change that. More recently, the 20th Amendment's framers, when they analyzed these contingencies, recognized even 150 years after the framing that electors still had discretion, and electors could and should use it in the case of death of a candidate. This shows that, given the current system of presidential selection by an electoral college, there must be times when electors, and only those electors, are best placed to act in the interest of country. Your Honors, the states have a problem with the idea of an electoral college, and they want to write it out. They make no bones about it. They haven't so far today. And perhaps we would be better off without indirect election, because this months-long, multi-step process of presidential selection presents some risk of instability no matter who wins this case. But until we have an Article 5 amendment, the vote of real humans, called presidential electors, isn't going away. To make sure the system we have works sensibly, given the Constitution we have now, when those human electors do vote by ballot, they must be permitted to do so with discretion, Your Honors.
Thank you, counsel. I'll begin by asking you the flip side of the question I asked General Weiser. Is there anything that Mr. Lessig said with which you disagree?
No, Your Honor. We filed an opening brief, and I'll sign on to exactly what he said in the first hour.
Thank you. You gave a number of examples there of situations that have gone awry, and there was no way to take account of them. But I'm not sure your position has any limits either. What are the limits to your position?
The limits, Your Honor, are that electors must be permitted to vote with discretion. And so, as Your Honor notes, there is a choice. There is always the possibility of bribery, always the possibility of corruption, and the framers considered all the possibilities and placed the ultimate selection of president in the hands of a group of presidential electors that were appointed by the state.
I take your answer when I ask for limits to be that they must be allowed to vote in their discretion, that you don't have any limits.
Your Honor, there are no limits in that voting by ballot so long as the ballot is for a person. The 12th Amendment says they must vote for a person. You can imagine, indeed you don't have to imagine that it's
not a giraffe? I mean, of course they have to vote for a person.
Your Honor, Congress concluded in 1872 that the Greeley vote wasn't a vote for a person because it was a vote for a non-living person. I'm sorry if I was unclear. That's the situation that I meant. But those are really the limits of the discretion there. There's great discretion in appointment. There's you know, the state can absolutely discriminate between all kinds of people, and they do on the basis of political party, for instance. But once the vote begins, that vote by ballot is the electors.
So the elector can decide, I am going to vote, I'm going to flip a coin, and however it comes out, that's how I'm going to vote.
Yes, Your Honor. That's the same discretion that U.S. senators have, representatives have, congressional electors have. These, too, are elected officials, and they have that same discretion.
Well, that sounds pretty limitless to me. Let's say that an elector has a contract. The different parties insist that electors sign a contract that you will vote, if we win the popular vote, you will vote for our party's candidate. And if you don't, there'll be liquidated damages of $1,000. An elector is selected and breaks that contract, votes for the other individual, even though that individual didn't win the popular vote. Can that contractual commitment be enforced by the state?
Not legally, no, Your Honor, and that shouldn't be surprising because that's the same prohibition that applies to congressional electors who cannot sell their votes, even though, as a condition of participating in a primary, and we cite these cases extensively in our reply briefs, you can force regular voters to take pledges and oaths to support a party. You just can't cross that line and enforce them.
Thank you, counsel. Justice Thomas?
Yes, thank you, Mr. Chief Justice. Counsel, you mentioned that senators are free to vote, or members of the House of Representatives, but there's some degree of accountability for them when they vote a particular way. what's the accountability here for an elector who strays from what is expected?
There are several forms of accountability, Justice Thomas. The first, of course, is the selection process, because they are party people, and in all 50 states they're selected by the political parties. From there, after the vote, they can be kicked out of the political party. They cannot win an election. They can have negative political consequences. And that's the exact same thing with senators, right? Senators do have accountability, but that accountability comes 6 years later. So if a U.S. senator, Justice Thomas, promises to support only low taxes, and then at every opportunity raises taxes, their only accountability is 6 years later. That's the nature of political discretion, and that's the discretion electors have here.
But there's also accountability in chamber, within the Senate. There's accountability as far as removal from office. But you're saying that with an elector that those other forms of accountability are not available.
They are, Your Honor. There is absolutely party discretion, party meetings, just like any other representative body. And just to quibble slightly, Justice Thomas, with what you said in terms of removal of a U.S. senator, there's no precedent that we have found of a U.S. senator being removed, perhaps even by an appointing governor in the case of a vacancy, on the basis of a vote. Certainly some sort of criminal misconduct, sure, but not on the basis of a vote. And that's really the same analogy here.
But let's say you mentioned with respect to the state that the state could not, that after someone dies, their system is so rigid that you can't make changes because of the death of the candidate. But I think that on your side, you, as the Chief Justice alluded to, you have a similar problem because the elector who had promised to vote for the winning candidate could suddenly say, I'm going to vote for Frodo Baggins, and I really like Frodo Baggins. And you're saying under your system, you can't do anything about that.
Your Honor, I think there is something to be done, because that would be the vote for a non-person. No matter how big a fan many people are of Frodo Baggins. That said, I do think the important point is that the framers hashed out these competing concerns. They hashed it out in Philadelphia in 1787. They understood the stakes, and they said among these competing hypotheticals, electors are best placed to make the ultimate selection. That hasn't changed, Justice Thomas.
Thank you. Thank you, counsel. Justice Ginsburg?
I don't understand your point about rigidity, because as I understand the state's position is, the states have a choice. They can say electors have an independent vote, or they can say the electors must follow the party's orders. So the states are not, the states are being given leeway to do it one way or the other way. So why do you say it's rigid when it seems to me it could be described as supple, because the states can have it either way?
Justice Ginsburg, the states do have great flexibility, as you mentioned, in choosing the mode and method of appointment. But the laws that they've written here, the laws that were enforced against my client, Mike Baca, are very rigid. They're rigid in the sense that there are no exceptions once passed. And that rigidity conflicts with the supposition that every single Congress that has looked at the issue of presidential selection has assumed exists explicitly in 1933 when the Congress drafting the 20th Amendment. That's a key oversight of these laws, but even down to the more modern era when Congress was debating the 24th Amendment, for instance, prohibiting poll taxes, and noted that it needed to bar poll taxes for elections for presidential electors because they still exist in our system. So that's the rigidity I'm talking about, Justice Ginsburg.
And how do you answer the standing question that you have no economic, Baca has no economic injuries or has no standing to complain?
There is standing, Justice Ginsburg. I will say there is a very small economic injury. We've asked for $1 in nominal damages. Mr. Baca gave up an additional $5 of salary. I'd just like to correct the record where Attorney General Weiser said there's no salary. Colorado Statute 1-4-305 provides electors with $5. That's at Pet App 10. So the stakes financially are small, but the stakes constitutionally and personally for Mr. Baca are large, and they're sufficient to confer standing.
Thank you.
Justice Breyer?
Thank you. To go back to the technical point, you brought a suit under 1983 and against a state, and it's fairly clear in the case law that you can't sue a state under 1983. What are we supposed to do about that?
Your Honor, I'll echo what Attorney General Weiser said, which is that it's, and indeed I'll cite the court's opinion just last week in the Simon-Smith case, when the court said that the court's job is to resolve disputes as framed by the parties. And so the only way that the court should look at that issue is if it's jurisdictional. And as Attorney General Weiser said, it's not. I'll give you two cites.
The problem that I see with the view is that then any two people, plaintiff and defendant, who would like an issue decided by us simply have to waive enough matters so that it has to come before us because it's not jurisdictional. They interpret the statutes differently. They do whatever they have to do. What are we supposed to do about that?
Your Honor, I don't think this case implements something like that because this case is one that courts surely could hear. It was initially brought individually against the Secretary of State through a compromise that involved the plaintiffs giving up a right to attorney's fees and other accommodations. It was somewhat reframed in order to be brought against the Department of State. And as the 10th Circuit said, I'll just point the court to Pet App 53 to 70 with a really...
But I'll look at that. One other question you didn't mention in terms of accountability, what I take it, why didn't you, is that Congress doesn't have to count a vote of a faithless elector. For at least 125 years, there were faithless electors from time to time. And Congress usually counted them, and sometimes they didn't. With Horace Greeley, for example, they didn't. So is that not a power that the Congress has to make certain that the faithless elector does not cause trouble?
Justice Breyer.
What's your view about that? What's your actual view about it? You didn't mention it, so you don't think it is, probably.
No, I think, Justice Breyer, to be clear, that the Greeley example supports our side. The Greeley votes that were rejected
I know
were actually faithful.
I'm interested in why you don't consider this as significant. I would like your true answer to that.
Your Honor, just so I understand, the Greeley votes, the three that were rejected by Congress, were actually faithful. They were electors that were pledged to Greeley.
But I mean, doesn't Congress's power, there's 3 U.S.C. Section 15, there's the Constitution saying counted. Does that act as a significant check on the faithless elector, or does it not?
It can, Your Honor. The courts and Congress have never interpreted the Electoral Count Act and what it means for a vote to be regularly given. Congress, I do think, possibly has the power to reject a faithless vote under certain circumstances, but we know it has never done so. Those Greeley votes that were rejected were faithful votes for Greeley, who is deceased, and the 63 votes of Greeley electors who voted for other people, who were faithless in some sense, those were all counted.
Thank you, counsel. Justice Alito?
We have to interpret the Constitution to mean what it means, regardless of the consequences. But I am interested in, at least in understanding what the consequences of your position would be. And we are told by experts on elections that the consequences would be potentially chaotic. I'm thinking in particular of Professor Bennett's brief, and there's been other writing by experts on elections that acceptance of your position would mean that after an election where the apparent outcome based on the popular vote is a small margin of victory for one candidate, there would be concerted campaigns to change that result by influencing a few electors, and that could be achieved by influencing just a few electors. That's just one of the consequences. There's the fact that in most states the electors are not even listed on ballots. and therefore the voters have no way of trying to ensure that the electors who were chosen are electors who really will honor the wishes of the voters. So do you really deny that this is where your argument would lead?
We do deny it, Justice Alito. And here I think past this prologue. Attorney General Weiser, in a response to a prior question on the same issue, noted that there had been campaigns already to affect electors. He mentioned 1876, the famously contested election of 1876. But in fact, Robert Alexander, a scholar of presidential electors who we cite on the last page of the reply brief in Shafalo, Alexander's research shows that there have been concerted campaigns in 2016, in 2000, and beyond, that some 20% of electors have contemplated switching their votes, and that 100% have been contacted. And
he denied that there's a greater chance of this happening. Didn't Mr. Lessig support such an effort in 2016?
Your Honor, Mr. Lessig has been representing these electors from the beginning in 2016. So
that wasn't my question. Didn't he advocate that some electors change their votes for the purpose of changing the outcome of the 2016 election?
Your Honor, I believe that he supported the legal discretion that electors have that we're here today arguing for. And the reason is, A, that that's in the Constitution, but B, that going back to the chaos point, the center has always held. The center has always held, we know that 18 states today, Justice Alito, have no such laws. And the states are not about to say that there's some constitutional requirement that they implement them. In fact, they say the reverse. They say it's a feature and not a bug, that there is federal
One more question, if I possibly can. Do the states have any power to remove electors? I can't think of any government office holder who cannot be removed from office.
Your Honor, yes, they do have some power to remove elector, just not a removal power that interferes with the core function of voting by ballot.
What is the limit of their power to remove?
The limit of the power to remove is, again, that interference with the core function. So if an elector does not show up to vote, the states have represented that it's our view that's impossible to remove and replace that elector. That's not true. That becomes a vacancy. The Electoral Count Act permits it to be filled. History shows that it can and will be filled.
Can an elector be removed for bribery? Absent conviction by proof beyond a reasonable doubt before the time when the electors need to vote?
No, we don't think so, Your Honor, and that's consistent with the treatment of every other elected official. Senators and representatives cannot be removed for a supposition of bribery, a mere whisper of it. They have to be removed for proof of it, and the same thing would be true here.
A member of Congress could not be removed from office by a two-thirds vote without a criminal conviction.
The Congress certainly has power to remove, but it must go through a full process. I took Your Honor to be asking about the sort of instantaneous, removal. One official, one single state official, is going to make a decision to kick someone out based on a rumor. That would be inappropriate for any sort of elected official, and it's inappropriate for electors.
Thank you, counsel. Justice Kagan.
Mr. Harrow, suppose that I read the Constitution and I find that it just doesn't say anything about this subject. That there is some hints here and there are some hints going the other way, and mostly I just read it and I say the Constitution is silent. What should I then do and why?
Justice Kagan, in that case, I think the original understanding would control. Again, we think there is clear language in the Constitution, and I want to return to that. But the original understanding would control because it is so clear, and indeed Colorado doesn't even necessarily challenge it, that the original expectation and the meaning of the word...
Sorry, do you mean the original understanding like prior to ratification? Because I would think that pretty quickly it flipped, even if you're right. So that from the first, there were these pledges, and there have never been a substantial number of faithless electors. So I would think that the history, both at the time and since, would cut against you, no?
No, Justice Kagan, because our quibble is not with the pledges, and our invocation of history is not with the pledges or the idea of party control and of having two major parties in our system. The idea is with enforcement of the vote. The idea is with what occurred here, removing an elector who actually votes. Mr. Baca actually presented a vote and attempted to vote and place it in the ballot box, and that was rejected. That is novel, Justice Kagan. That has only happened in 2016, despite the party control of the selection process.
What would you think if I said that if I think that there's silence, the best thing to do is leave it to the states, to not impose any constitutional requirement on them?
Your Honor, I would push against because I don't think there's silence, right? Especially here in this.
I know, but that's the hypothetical. I just, if I just think that there's not enough, in the same way that Ray thought that there was not enough to provide an answer to the question, and there are all these states doing what Colorado is doing, why not just leave it to them?
Because, Your Honor, when Justice Kagan, when you said there are all these states doing what Colorado is doing, it has actually never been the case that a state has done what Colorado is doing. It's 220 years of unbroken history. I think that speaks very loudly if Your Honor is concerned about how to interpret that silence. And so,
go ahead, please.
No, Your Honor. If you're ready to move on, that's fine. I was going to continue making another point.
No, that was directed to Justice Kagan.
No, I'm done. Thank you.
Okay. Justice Gorsuch?
Counsel, suppose Mr. Baca had asked Congress to count his vote, and Congress decided to do so. Would we be here?
Yes, you would, Your Honor. There is no mechanism for Mr. Baca to ask Congress to count his vote under the Electoral Count Act that the state has pointed to any mechanism other than perhaps making a phone call to a senator. The same.
I believe you're getting my hypothetical. Let's suppose he had asked Congress, and let's suppose Congress had agreed to count his vote. That's my hypothetical. Would we be here?
If Congress had counted his vote instead of the vote of the replacement elector, Celeste Landry, then no, perhaps not, because in that he wouldn't have lost the office. I will say he didn't get a chance to vote for vice president either. So assuming on Your Honor's hypothetical that he had his ballot fully cast, then no, we probably wouldn't be here.
Okay. He didn't try to ask Congress to cast his vote, did he?
He did not, Justice Gorsuch. There's no mechanism for it, and the state hasn't pointed to one.
Okay. And the damages he seeks are, is it $6? Is that right?
Justice Gorsuch, it's even less. It's $1 in nominal damages.
$1. So it's a $1 nominal damages. And why should we exercise our discretion to hear this case when the nominal damages are $1? You didn't seek Congress to count his vote, though, as you point out, it's unclear whether there's a mechanism to do so. And we have a cause of action that doesn't exist that we are asked to overlook because of a stipulation by the parties. Why isn't that a sort of manufactured litigation that this court should decline should bother with using its discretion whether to decide a case?
Justice Gorsuch, because once there is jurisdiction, and again, I'll just emphasize that the question of whether
I'm accepting there's jurisdiction, counsel, but this court has discretion over what to entertain. And it also has some authority to emphasize the importance of the adversarial process and its proper uses.
It does, Justice Gorsuch, and I think the arguments today in the brief show this is highly adversarial on the standing and on the merits. And the discretion here is because there was a conflict in the lower courts on an important issue, and the unique chance that this court has to decide this issue of presidential selection outside the very contested context of an actively fought presidential election. So to the extent Your Honor is talking about discretion and not jurisdiction, I think it's well exercised here. And again, Colorado doesn't contest that.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice, and good afternoon, Mr. Harrow. How, if at all, should the quick growth of political parties affect our analysis of this case, including how the 12th Amendment interacts with Article 2?
Justice Kavanaugh, the political parties provide the context for nominating electors and the appointment of electors. But the fact that there are political parties now and were emerging political parties when the 12th Amendment was passed in 1803 doesn't affect that the word elector remains in the Constitution and that electors are people who vote, and all of those words and all of those structural principles mean that they can vote with discretion.
Then Justice Kagan noted a question about what to do if the text is silent. And we've talked about various things that could fill the gap there, including the state's authority. Another, of course, under our case law is historical practice, under cases like Noel Canning and Dames and Moore and many others, that we look to historical practice as a gloss on the text. What is your strongest point on why the historical practice favors you rather than favoring the other side?
Justice Kavanaugh, in addition to the historical practices that we've already discussed, including in the exchange with Justice Kagan, I'll also point the Court to the history of constitutional amendments that have been introduced to try and abolish the office of elector, precisely to eliminate the elector discretion that everyone who was introducing the amendment assumed exists. As we point out in our brief, this starts in 1801 with no less than Thomas Jefferson saying, hey, maybe we should get rid of the office of elector. They can only cause trouble. And that continues in the 19th and 20th century. For 20 years, such amendments were introduced by Thomas Hart Benton in essentially every single Congress. And those amendments were not meaningful. And the people who thought that we ought to eliminate elector discretion were not writing on a blank slate. They were writing knowing there was elector discretion, and that would be a lot of wasted oxygen, Your Honor, if there was already a way to eliminate elector discretion and if they didn't have it in the first place.
Thank you very much.
Counsel, you have a few minutes for a wrap-up, if you'd like.
Sure. Just to conclude briefly, as the Court knows, the intervention here was extraordinary and unprecedented. And if Colorado was permitted to undo the human check that has been baked into the system of presidential selection, there really could be a chaotic outcome. By contrast, most electors have been free in most elections, and here we are today, Your Honors. Indeed, electors retain legal discretion in 18 states, as I said, and a decision from this Court won't change that. So the question for this Court is whether to approve of the state's novel intervention, and it is novel, and be left wondering how the state's overly rigid interpretation could go haywire in, as we've discussed, the case of death or other unforeseen circumstances, or instead whether the Court should keep faith with the system, keep faith with the Constitution until amended, and maintain indirect election, acknowledging that both sides have a vision of presidential selection that is imperfect. But the various checks, balances, and separations that our Constitution's drafters and amenders have put into the Constitution, all of those should be given a role in our constitutional universe. And, Your Honors, I think that all adds up to elector discretion. Thank you, Mr. Chief Justice.
Thank you, Counsel. General Weiser, you have 2 minutes for rebuttal.
Thank you, Mr. Chief Justice. Let me make 3 points in response and offer 2 closing thoughts. First off, on standing, the payment or non-payment of the per diem fee was never before alleged, and any reported non-payment is not in the record. Second, on nominal damages, prior cases like Smith and Byrd did not accord standing on nominal damages alone, instead focusing on whether there's an actual personal injury. Second, as to Justice Scalia's important point about congressional removal in the case of bribery, it's worth noting there is a prescribed removal process for senators, as Justice Alito noted. In the case of electors, there's no such process, which means this Court's default rule controls. The power to remove is thus incident to the power to appoint. Third, it's worth noting this is the first time we've seen an elector who violated a state binding law. Up until now, including the 2016 election, we've always seen Congress defer and count votes as transmitted by the states. 2 closing thoughts. During the course of this entire litigation and this argument today, my friends on the other side have failed to offer any viable theory on how to address the spectacle of a bribed elector, an elector who votes for photo baggins, or one who would perpetrate a bait and switch on the people of her state. Colorado's pledge requirement addresses all such harms. After over 230 years of constitutional tradition, my friends on the other side would toss out our nation's state-centered model of electoral accountability in favor of a treacherous experiment. We urge this court to reject this dangerous time bomb and avoid a potential constitutional crisis by reversing the 10th Circuit judgment. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned sine die.